Good afternoon and welcome to the ISSUP South Africa and ITTC South Africa webinar. We are presenting the webinar with the title The Child Justice Act 2008 and the use possession of cannabis by children. Just a little bit of housekeeping. The webinar is scheduled to run from 1 p.m. to 2:30 p.m. The presentation should be about an hour with a brief question and answer period after. Please post any questions you may have during the course of the presentation in the questions portal that you see on the top right hand of your screen. Should we not have time to respond to all the questions, we will ensure that your questions are answered in the follow-up that will be responded to when we post the recording of this webinar. As I said, the title of the webinar today is the Child Justice Act 2008, Act 75 of 2008, and the use, possession of cannabis by children. Just a bit of background, the Child Justice Act 2008, which came into operation the 1st of April 2010, created a separate criminal justice system for children. It changes the way we deal with children who have committed crime. Recent developments in case law focused on the use and possession of cannabis by adults and children. This webinar will look at these changes and the way forward in dealing with children using or possessing cannabis. It is our privilege to present our, to introduce our presenter today, Dr. Charmain Badenhorst. Dr. Badenhorst is the Director for the Child Justice and Family Law in the Department of Justice and Constitutional Development. Dr. Badenhorst holds a B.luris, an LLB, a BA Honours in Criminology, a Masters of Arts Criminology, a DLitt et Philosophy in Criminology, and has also been admitted as an advocate of the High Court of South Africa. She commenced her career as a prosecutor in the magistrate court and has 18 years experience in the legal and crime prevention environment. Dr. Badenhorst specializes in child justice, criminal justice, crime prevention, and research and the development of safety strategies. She's also worked as a senior researcher at the Council for Scientific and Industrial Research. And as I said, is currently the Director of the Child Justice and Family Law at the Department of Justice and Constitutional Development. Dr. Badenhorst has also been the author of various publications on child justice. Dr. Badenhorst, we at ISSUP and ITTC are very privileged to welcome you to present for us, and we look forward to your presentation. Thank you very much for joining us, and I shall hand over to you now. Thank you.
Thank you, Roger, and good afternoon to everyone attending. I'm going to jump right into the presentation. So basically, I'm going to focus on the child justice. I can't move the slides. So basically, I'm going to. I don't know.
Bear with us. You know, technology is always a problem. Dr. Badenhorst, if you just click on the screen in front of you and see if it, if you can use the arrows to press. Yeah, if you can proceed to the next slide.
Did it move?
No, it hasn't happened. If you go onto your desktop and onto the PowerPoint slide presentation that you have open, and click on that, and then see if it, and try and move the slide.
Okay, something happened. Okay, I don't know. Yeah, okay. All right. So basically, I'm just going to highlight some of the guiding principles of the Child Justice Act, the aims of the Act, how we deal with children under the age of 10, that is children that do not have criminal capacity, the changes that were brought about by the Act in terms of criminal capacity, the police's responsibilities, the assessments being done with children in conflict with the law, diversion process, the preliminary inquiry, the Child Justice Court, and sentencing. I will also then do a discussion on the case that was before the Gauteng South High Court, the state versus LM and others, that brought some changes in terms of how we deal with children using and possessing cannabis. Then I'm going to focus on the alternatives in terms of the Child Justice Act, the Prevention of and Treatment for Substance Abuse Act, and also the National Instruction by the South African Police, which deals with children in need of care and protection. So, first of all, the guiding principles from the Child Justice Act indicates that the consequences arising from the commissioning of an offence by a child should be proportionate to the circumstances of the child, the nature of the offence, and the interests of society. It also tells us that a child should not be treated more severely than an adult would have been treated in the same circumstances. And every child should be given the opportunity to participate in the proceedings, particularly in the informal and inquisitorial proceedings, where decisions affecting the child may be taken. We want the child to be part of that proceedings. The child should also be addressed in a manner that is appropriate to his age and intellectual development. And then they should be allowed to speak in their language and spoken to in their language of choice, where interpreters should be used if necessary, and that all the procedures in terms of the Child Justice Act should be conducted and completed without unnecessary delay, because that is always in the best interest of the child to be dealt with as quickly as possible. So furthermore, it also guides us to say that the parents, appropriate adults or guardians, should be able to assist the child in the proceedings, and they should also be encouraged to participate in the process, because decisions are always taken which also affect the parents and the adults and the guardians who look after the child, and they should be able to support the child in whatever outcome the court decides on. And then it says every effort should be made to ensure that children receive similar treatment when they have committed similar offences, so that we don't find that some children are sent to prison where others are given a fine when they've committed more or less the same offence. And then we always have to take cognizance of the rights and obligations that we as a country have engaged in the international and regional instruments, the United Nations Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child, as well as our Constitution. So if we look at the aims of the Act, first of all, it is to establish a criminal justice system for children in conflict with the law, which is in accordance with our Constitution and also the international obligations that we have as a country. And with the main feature of this separate system that we have created through the Child Justice Act is to create the possibility of diversion, diverting children out of the criminal justice system, and then to provide for child justice courts where we cannot divert these children from the criminal proceedings. It is also to expand and entrench the principle of restorative justice in the criminal justice system or child justice system, but we must also ensure then that children take responsibility and accountability for the crimes that they have committed. It also aims to prevent crime through the emphasis on rehabilitation and reintegration of children back into the communities to minimize the potential for reoffending. We need to balance the interest of the children and those of society, and we must take due regard to the rights of victims. So the Act also aimed then to improve the situation of children. First of all, it raised the minimum age of criminal capacity, which I will go into a bit later. It provides for the assessment of all children in conflict with the law so that we can have an individualized approach towards each and every child. It also established special processes to secure the attendance of children, not necessarily to arrest and detention, and also added additional considerations when considering the release or the detention of children. It created the preliminary inquiry process, which is an informal inquisitorial process, which I will also discuss later on. It provides for diversion, diverting children out of the criminal justice system. It creates or establishes child justice courts, where children then appear if the cases are not diverted, and it creates sentencing options that is suited to the needs of children specifically. So first of all, we have our children under 10. So children under 10 do not have criminal capacity or criminal responsibility, as it's often referred to, and they cannot be held responsible for the commissioning of the offence. So the police, if such a child commits a crime or alleged crime, the police may not arrest the child, but the police must hand over this child to the parents, and if it's not in the best interest of the child to be handed to the parents, depending on the circumstances, they must hand the child over to a child and youth care center to just keep the child, not detain the child, but just until the parents or a guardian or appropriate adult can be get hold of. So as soon as the police comes across a child that has committed a crime under 10, they must immediately inform the probation officer. And the probation officer must then assess this child within 7 days after they've received this notification. And then following this assessment, there's various actions that the probation officer can take. The probation officer can refer the child to the children's court if it is found that the child is in need of care and protection. They can refer the child for counseling or therapy, or to refer them to an accredited program, or to arrange support services for the child, or arrange a meeting with the parents of the child. Or if the child was merely naughty and there's not really any interventions needed, they can decide to take no action. But they must record the outcome of this investigation and the reasons for the decision that they have taken. And that is to ensure that we don't miss the opportunity of intervening and preventing these children from coming into the system at an older age. The next issue that I want to focus on is the criminal capacity. So before the Act came into operation, common law governed the issue of criminal capacity, and I'm sure that many of the attendees will remember that at that time, before the Act came into operation, the minimum age of criminal capacity was 7. So if a child was over the age of 7 and they've committed a crime, they could be arrested by the police, and then there was a rebuttable presumption operational for children between 7 and under 14, where the child, the state have to prove the criminal capacity of the child. The Child Justice Act have increased this the minimum age of criminal capacity, and we are in the last processes of increasing it to 12. So as soon as the regulations are approved by Parliament and the President issue a proclamation, the amendments that we've already effected to the Child Justice Act will come into operation, which will then mean that police cannot arrest children under the age of 12. If the police arrest a child between the ages of 10 and under 14, the state must prove the criminal capacity of the child, and that is done in a 2-tier process. The state must prove that the child had the capacity to appreciate the difference between right and wrong at the time when they committed the offence, and they must also prove that the child had the capacity to act in accordance with that appreciation. So that is an additional element that the state must prove when they are charging a child between those ages, and if that is then successfully proof, then the child can be convicted for the offence if all the other elements of the crime is met. And currently the Act provides that if you cannot prove criminal capacity, you foresee that the child may not have criminal capacity, you can also not divert the child, because the child needs to take responsibility for the commissioning of the offence. And you cannot really expect a child who doesn't understand the difference between right and wrong to accept responsibility for that. And also, if there's no criminal capacity, if the state cannot prove criminal capacity, then there's no conviction. The Act provides for the evaluation of a child, for the criminal capacity of the child. The elements that are focused on during this assessment is the cognitive, moral, emotional, psychological, and social development of the child, and the suitable qualified persons being identified by the Act is psychiatrists, clinical and educational and counselling psychologists. So we've also expanded on the professionals that can do these kind of assessments. In the past, it was only clinical psychologists and psychiatrists. So moving on to the police, and there are three ways that the police can get the child to appear before a court. The police can arrest the child, they can issue a written notice, or they can summons the child to appear before a preliminary inquiry as soon as the child is apprehended for the commission of an alleged offence. The Child Justice Act provides for various schedules of offences. And it goes from Schedule 1 to Schedule 3. Schedule 1 is your least serious or minor offences, which is a malicious damage to property, for instance, where the value is less than 1,500 Rand, common assault, contempt of court, criminal injuria, etc. Schedule 2 is your more serious offences, that is culpable homicide, arson, housebreaking, abduction, etc., etc. And then your Schedule 3 offences, you'll hear me referring throughout the presentation to these schedules. Schedule 3 offences is your serious ones, your murders, your rape, your kidnapping, robbery, where there is aggravating circumstances, and sexual assault, and so forth. So the police may not arrest a child for a Schedule 1 offence unless there are compelling reasons to justify such an arrest, and that is where the child don't have a fixed residential address, for instance, or where they suspect that the child will continue to commit crimes or is a danger to others. But if the police do arrest that child, they must make a report as to why did they arrest the child on a Schedule 1 offence with these reasons that they took when doing the arrest. Or yes. So the Act states that the police must then inform the probation officer immediately of the apprehension of the child, but not later than 24 hours. So the idea is that as soon as the child is arrested or apprehended, the probation officer should be informed immediately, and the police officer must also inform the child and his parent, guardian, or appropriate adult about his rights in terms of following his arrest, the charges against him, and what will immediately happen next, so that they know what to expect. What is the next step? What's going to happen next? So the next step then is the assessment by the probation officer. The Act provides that every child in conflict with the law must be assessed. And the reason for that is because we want to ensure that children who are in conflict with the law are treated in an individualized manner, so that we take the circumstances of the child into consideration when we take decisions regarding how to deal with this child. And this assessment may be dispensed with by the prosecutor, for instance, if the case is diverted before it's going to the preliminary inquiry. But if this happens, then the court must record the reasons why they've dispensed of the assessment, and it must be in the best interest of the child as our constitution demands. Then the assessment must happen before the child appear in the PI. And that is the reason that when the child, the reason is that if the child appears in the PI, the magistrate and the prosecutor are aware of the child's circumstances, and that will assist them then to take a decision as to how to take this matter further. I've already referred to the issue of the assessment of children under 10, so I'm not going to repeat that. The Act also states that this assessment can take place in any suitable place, so it can either be at the police station, at the court itself, in a room, or at the offices of the Social Development, Department of Social Development, but the space that is used must be conducive to privacy, so that the child can then share all the information that is necessary for the probation officer to be aware of. The child's parent, guardian, or appropriate adult must attend the assessment, and unless they've been exempted by the social worker, or sometimes they can be excluded, depending what is in the best interest of the child and the circumstances of the specific case. The diversion service provider can also be part of the assessment, research, or any other person, but that's depending on the best interest of the child. And again, the Act places the responsibility on the probation officer to explain to them the purpose of the assessment, their rights, and what will happen next. And in this assessment, the probation officer will also find out from the child whether they accept responsibility for the commissioning of the offence, because that will play a role in the suitability of the child to be diverted or not. So the purpose of the assessment is then to ascertain whether the child is in need of care and protection. Sometimes children commit crimes because they are children in need of care and protection, and that is an opportunity for the probation officer to investigate that and to be able to report that to the court. It's also to estimate the age of the child. Sometimes it's not clear how old a child is. We know, I think a lot of the challenges in this regard have been addressed by efforts that the Department of Home Affairs have made to register children at birth, but there are still children that where the age are not clear, especially if it's children, orphan children, or children living on the streets and they can't find a family. So sometimes there's a need to estimate the age of the child. The probation officer must also then look at whether there was any previous convictions, any previous diversion, or any pending charges against the child, because that will also have an influence on how to deal with the child. It must also make a recommendation whether the child should be released, either in the care of the parents or guardian or appropriate adult, or on his own recognizance, or whether the child, or on bail, or whether the child should be detained, and if so, where should the child be detained? You have the option of either a child and youth care center or the correctional facilities. But that's something that the probation officer makes a recommendation on, taking all the facts into considerations. So the assessment is then again, what measures to take if the child is under 10. I've already addressed that. And then also whether they are of the opinion that whether the child have criminal capacity, the two-legged approach that I was referred to earlier, and it's just a opinion of the probation officer whether they think this child do have criminal capacity or not. Another important issue that the probation officer needs to look at this stage is whether the child was used by an adult to commit a crime, because that will have an impact on the way that we deal with this issue and with the child. And that is something that they will also then bring to the attention of the court. And then, of course, any other relevant information that the probation officer feels that is important for the court to know about. So then the report will then contain the possible referral to the children's court because the child is in need of care and protection, the appropriateness of diversion, and here the fact that the child has acknowledged responsibility for the crime is one of the issues that needs to be taken into account. The possible release of the child because of the interaction that they've had with the parents. Sometimes parents don't have control over the child, but that may also then lead to a child that is in need of care and protection. And then two, if detained, where must the child be placed? Measures for the child under 10, measures to be taken to prove criminal capacity. Maybe the probation officer spoke to a teacher or to a parent which may have information that the court might find relevant. And then in some instances, the probation officer can indicate that a further detailed assessment is necessary. And that is in cases where the child is a danger, maybe a danger to himself or to others, when the child has a history of offences or of absconding, where there's a social welfare history that warrants a further assessment, or if there's a possibility that the child may be admitted to a sex offenders program or substance abuse program, and they just need a little bit more time to be able to finalize those arrangements. And then, of course, the probation officer must also indicate if there was a need to estimate the age, what the age is that the probation officer think the child is. The court also have a process of dealing with that, and at the end, the court's order in that regard will be the one that will be going forward. This is just a recommendation by the probation officer. So the process of diversion, which is central to the Child Justice Act, and it's something that was brought in by the Act, as I said earlier, but it was something when I was a prosecutor in the early 90s, we had these informal diversions, and it was happening in some courts and it wasn't happening in some courts. So the Act now makes sure that it happens in all courts, or that in all cases it's considered. So diversion is a way to channel away prima facie cases. Now, prima facie cases is cases where there is enough evidence for that will lead to the conviction of a child. So if the case is not if there's not enough information in the case, or there's no prima facie case, you cannot divert the case, because then you're holding someone a child responsible for a case which you can't prove. So that is the purposes of diversion, is to take children out of the formal court proceedings. And prosecutors can divert cases, Schedule 1 offences, that's your minor offences, before the preliminary inquiry. So after they received the docket, they looked at the assessment, they can decide to divert the case and then just make the diversion order an order of the court. And then if no assessments was done, the reasons for that must also then be recorded by the court. And as I said, criminal capacity must be established, or there must be certainty that the child do have that capacity I referred to earlier. There are two levels of diversion options in the Child Justice Act. The level 1 diversion is for your Schedule 1 offences, your minor offences. And these options include various orders that the court can make. For instance, good behavior orders, school attendance orders, family time orders for a specific period of time. The Act do have specific periods of time depending on the ages of the children. Restitution is also the restorative justice part, is also part of the level 1 diversions. the child can apologize when he committed the crime, and that may, and maybe write a letter of apology to the victim. That is the kind of options that we're looking at. Referral to therapy programs also form part of the level 1 diversions. The level 2 diversion options are more erroneous, if I can call it that. It can be a combination of the level 1 diversion options, but it also provides for compulsory residence in a child and youth care center for a specific period of time when the child have committed a serious offense, because the level 2 diversion options are available to your Schedule 2 and your Schedule 3 offenses, which is the serious offenses I was referring to earlier. So and it can be a combination, as I said, and there's also time limits to this diversion option depending on the age of the child. Diversion is often referred to as soft options, but if the diversion order is framed correctly and the child understands what the consequences will be if they don't comply with the diversion order, it is if it's implemented correctly and properly, it should not be a soft option, because the child needs to take responsibility for the crime that they have committed. A unique feature of this option is that all offences can be considered for diversion depending on the circumstances of the case. So in some countries you have diversion being part of the child justice system, but it's only reserved for specific offences. In South Africa, we don't have that. We have it can be considered in all the offences. In the case of Schedule 2 and Schedule 3 offences, the victim do have a say in that. It's one of the factors that the prosecutor takes into consideration. It's not the deciding factor, but the victim must be consulted, as well as the investigating officer that has the information about the child's past criminal activities and circumstances of the case. So the next slide it's the factors that I was referring to earlier when you can consider diversion. There's some considerations or factors that must be present. First of all, the child must acknowledge responsibility for the offence, and this acknowledgement must be without undue influence or any coercion from anyone. It must be out of the child's own free will. There must be a prima facie case against the child, so there must be enough evidence to convict the child. The child must also consent to diversion, and the parents, where they are available, they must also be consent, and because they are the ones that will have to support the child in this diversion process. So the case can also only be diverted if the prosecutor or the director of public prosecution, depending on the severity of the offence, indicate that the case may be diverted. And I've already referred to the way that we deal with Schedule 2 and 3 offences with the victim and the investigating officer. So if the case is not diverted, then during the PI, the case must be referred to the Child Justice Court. But that's not the last time that diversion will be considered. Diversion can also be considered during the trial in the Child Justice Court. So we have various stages where the child can be diverted, because there may be evidence coming out of the trial which now makes the child more suitable for a diversion than the information that was available during the preliminary inquiry. So then the child will be referred to the Child Justice Court. The Act also expects the probation officer to monitor the child's compliance to the diversion order, to whether he should have attended a program, whether he should attend school. The importance of this is that the child do realize that there are consequences if they don't. So they don't get an order and go home and forget about it. They must comply with the diversion order, and the probation officer at the end of the diversion order must report to court to say the child completed the diversion successfully, or the child did not complete the diversion successfully. So if a child do not successfully complete the diversion program, then there is a process that needs to be, the child needs to be called back to court, and the magistrate must hold an inquiry to find out what is the reasons why the child have not complied with the diversion order. So in this inquiry, we distinguish between whether it was the child's fault because he didn't want to attend, or he didn't feel it important enough to attend, or whatever, or whether it was because of factors outside of the child's control. So you might find that the child that didn't have transport money to get to where the program was being offered, or whatever reason there may be. So the court must do an inquiry and then decide whether it was the child's fault or not. If it was not the child's fault, then the prosecutor can, in both instances, whether it was the child's fault or not, if it was not the child's fault, then the court can give another a diversion order, which the child can then comply with, because they will then eliminate challenges that the child had for attending the first diversion order. If it was the child's fault, the prosecutor can decide whether they want to have a more onerous diversion order, or whether they're going to proceed with the trial and charge the child through the child justice court. And that is it. That is why it's important that these provisions are explained to the child and to the parent, so that they can understand what the consequences will be for not complying with the diversion order, especially if it is the child's fault for not attending. The Act also provides for minimum standards for diversion programs, and that is basically just to indicate that it may not be exploitative or harmful to the child. It must be appropriate to the maturity and the age of the level and the age of the child. It must not interfere with the child's schooling, and it may not exclude children because of a lack of resources. As I was referring to earlier, maybe the child don't have transport money to get to the diversion program. The Act also provides for the accreditation of diversion service providers and programs, because we need to ensure that if we divert children, that we divert them to programs that will actually provide a proper intervention to prevent the child from coming back into the child justice system at a later age. The diversion can also take on a very restorative justice approach, where it can order a family group conference or a victor offender mediation, which will then assist the child in taking responsibility, and it will also assist in preventing the child from committing another crime, depending on the circumstances of the case. The next process is then the preliminary inquiry. I've already stated it's an informal pre-trial procedure, which is inquisitorial in nature. So during this process, the court wants to know who is this child, what is the circumstances, what is the offence that has been committed, and how can we best deal with this child in this instance. It's regarded as a first appearance in a criminal court. So if a child is arrested and detained, they must appear before a preliminary inquiry within 48 hours, just like adults have to, and to ensure that we protect the best interest of the child. The child, the parent, the guardian, or appropriate adult and the probation officer must attend. In this instance, the court can also exclude a parent or a guardian or appropriate adult, depending on the circumstances and the best interest of the child. Sometimes a child is used by a parent to commit a crime, and then it will serve no purpose to have that parent present in the preliminary inquiry. The Act is very stringent about the postponement of the preliminary inquiries. There's very tight time frames, because in essence we want to finalize these cases as quickly as possible because it's in the best interest of the child. The child can have legal representation during the preliminary inquiry, but the prosecutor and the magistrate is also there to protect the child's best interest, but there's no reason why there cannot be a legal representative depending on the circumstances. And legal aid do provide legal representation for children in preliminary inquiries where the administration of justice demands it, depending on the circumstances of the case, but they are available to provide that representation. So the objectives of the preliminary inquiry is then to consider a report of the probation officers, the different issues that I've referred to earlier, whether the matter can be diverted, whether it should be referred to the children's court because the child is in need of care and protection. If the prosecutor indicates that the matter cannot be diverted, the child can be released in the care of the parents on bail or on his or her own recognizance. But sometimes children have to be detained or because of the factors that the court take in account. Then the preliminary inquiry magistrate must then decide where to place the child and also then refer the matter to the child justice court when it's not diverted or referred to the children's court. And the magistrate will take into account all the information and the views of all the persons before they make a decision as to how to the placement of the child or the diversion of the child. So this is an informal process, as I indicated earlier, and the Act do encourage the participation of all the affected parties to put the court in the best position to be able to make a decision in this regard. So if the case is not diverted or referred to the children's court, the child then moves on to the child justice court. We call it the child justice court. So basically a district court, a regional court or a high court becomes a child justice court the moment that the child appears before that court. So then immediately the provisions of the Child Justice Act kicks into operation and the court is then regarded as a child justice court. The Child Justice Act provides that the child must have legal representation during the trial in the child justice court. So the child cannot waive his right to a legal representative in the child justice court, and even if he refuses to speak to the lawyer or to give instructions to the lawyer, the legal representative must be present to ensure that the child's best interests are protected at all times. And Legal Aid South Africa do provide for the representation of children in child justice courts. Children can be charged with adults because sometimes they do commit, especially if it's a 17-year-old, they might commit a crime with an 18-year-old. So the 18-year-old is regarded as an adult, whereas the 17-year-old is regarded as a child. And in that regard, then, the Criminal Procedure Act will apply to the adult, and the Child Justice Act will then provide for the protection of the child in terms of when the court considers releasing the child on bail, or if it gets to conviction, the special considerations when sentencing a child. Proceedings in child justice courts are held in camera. It means that no public are allowed into the court. It's only the persons that are allowed by the magistrate to be part or is part of the proceedings. And also the identity of the child must be protected. And there was recently a constitutional court case with Media 24 where before this judgment, the protection of the identity of the child was up until they reached the age of 18. So if they want to publish information after the child reached 18, they could publish the child's information, but with the Constitutional Court, there's now additional protection for children, so that when they become adults, they won't open the newspaper one morning and find their names being put into the newspaper because they've committed a similar crime than a case that is currently enjoying a lot of media attention. The Act also requires the parents to assist the child during these procedures and to be present during the court procedure. And even in the Child Justice Court, there may be information that comes to light that will indicate that this is actually a child in need of care and protection. So at this stage, the court can also refer the matter to the Children's Court, which will then close the criminal case against the child, and the child is then referred to the Children's Court for an investigation into the circumstances of the child and a decision, you know, as to how to intervene in this child's life to ensure that they get the necessary support as children in need of care and protection. As I stated earlier, diversion can also occur in the Child Justice Court, and that is applicable during the trial up until before the state closed their case. So at any time before that, the prosecutor may find or request the court or recommend to the court that the matter be diverted depending on the circumstances, and maybe there was evidence brought to court that now makes a decision in that regard justifiable. Also, the court has the Act also look at the postponement of proceedings, and if a child is detained in a child and youth care center or in a prison, there's certain time limits as to the postponement of the case, and because we want to ensure that in cases where children are detained, that the cases are being dealt with as quickly as possible. And for a child that is detained in a correctional facility, they must be brought to court every 14 days, and children that are in child and youth care centers must be brought to court every 30 days. And during that appearance, every time that the child is there, the court must consider the continued detention of the child. So the court must revisit that decision to detain the child at every appearance in court, because sometimes circumstances may have changed and it's now desirable not to detain the child any longer, but to release the child into the care of the parents, or on own recognizance or on bail. And that is in line with the Constitution, which require us that detention should be as a measure of last resort and for the shortest appropriate period of time. The next phase of the trial I'm focusing on is the sentencing. So there's the objectives of sentencing in terms of the Child Justice Act is to encourage the child to understand the implications of the crime that they have committed and to be held accountable, to promote an individualized response. The triad, which we often refer to, is the child, the nature of the crime, and the interest of society. It's also to promote the reintegration of the child back into the family and the community, and sorry, and to lessen the opportunity or the risk of the child reoffending. And as I said, imprisonment should only be used as a measure of last resort, and also for the shortest appropriate period of time, in line with the international instruments and our Constitution. So the Act also provides for victim impact statements, and that is to give a voice to victims. So the victims can prepare a statement, or they can testify in court just about the crime and the effect that the crime had on them, the psychological, financial effect, and that's something that the court will then also take into account. The Act also requires that a pre-sentence report must be obtained from a probation officer in all cases where a child is being sentenced, unless there will be undue delay in getting that pre-sentence report, which is not in the best interest of the child. But if a child is sentenced to compulsory residence in a child and youth care center or to imprisonment, the court must get a pre-sentence report. The child cannot be sentenced without that pre-sentence report. And even if the court suspend the sentence, so sometimes you'll find that the court will convict a child and say that you are sentenced to 2 years imprisonment, suspended for 5 years on the following conditions. In those instances, there must also be a pre-sentence report, because if the child don't comply, then the sentence will be put into operation, and then we've missed the opportunity of a proper pre-sentence report by the probation officer, looking again at the circumstances of the child and recommending a sentence that they've that in their opinion will be in the best interest of the child. The court may deviate from the recommendation of the probation officer in the pre-sentence report, but the court must enter reasons why they deviate from that recommendation by the probation officer. So I've earlier indicated that sentence options are available to take into account the special needs of children. So the different options that we have in terms of the Act is community-based sentences, restorative justice sentences, so the court can suspend a sentence on condition that the child attend a family offender mediation or a family victim offender mediation or a family conference, or that he there's some kind of restitution where he must go and fix something that he broke or whatever. So that's also part of, that is something that the Child Justice Act encourages, is restorative justice approaches in dealing with children. Then the court can also sentence the child to a fine. And we often know that if that happens, then it's the parents that have to pay the fine. So there are also alternatives to fines, which the Act provides for. And before the court will fine a child, and that is also applicable when they consider releasing a child on bail, the court will first of all hold an inquiry and see, you know, what is the affordability of paying a fine or paying bail, just to put all the circumstances into perspective, because you don't want a child in a facility being detained because they can't afford to pay bail of 500 Rand, for instance. So that is also part of the fine, the sentencing to a fine. You need to find out whether because usually a fine is you pay so much money or you are sentenced to 3 months imprisonment. So it's to ensure that children don't get the worst part of that sentence because they can't afford to pay a fine. Then the court must look at the alternative. The Act also provides for correctional supervision, where there's also a sword over the child's head because they must do specific things whilst they are under correctional supervision. The court can postpone or suspend the sentence. The child can be sentenced to compulsory residence in the child and youth care center. That is usually, according to the Act, that's only for a period of 5 years or when the child turns 21, whichever comes first. So if it's a 17-year-old, the court have to take into account how much time is left before he turns 21, and then also imprisonment for your most serious offences, and after you have considered all the other sentencing options. So that is basically, in a nutshell, the Child Justice Act. And just some of the provisions I wanted to highlight, which I'm of the opinion that really do assist in the protection of children, the rights of children in conflict with the law. So the next slide is the state and LM and 3 others. So basically what happened in this case is that in a school, there was a search and seizure in terms of the Schools Act, and some children were tested positive for the use of cannabis, and they were all arrested by the police and they were brought to the prosecutor. because they've all tested positive for cannabis. So what happened then is the prosecutor decided to divert, because use and possession of drugs or cannabis is a Schedule 1 offence, so it's one of the minor offences. So the prosecutor decided to divert this case before sending it to PI. There was no probation officer's report at that stage, and the court ordered then level 1 diversion. I think it was about 20 children that were initially brought to court. The diversion order that was issued was a Schedule 1 diversion level 1 option, but in that order, they've basically used all the different options for a level 1 diversion. So the child had to attend, comply to a good behavior order, to a family family time order, to the discretion of his parents. So it was a very vague order, but it had all the options. It was like throwing the book to those children. One of the conditions was that the children's marks had to improve by 10%. They had to attend all the cultural and sporting activities at school, etc., etc. So it was a very onerous level 1 diversion order. So 4 of the children did not comply with this order, and the probation officer reported this to the court, and then they brought those 4 children back to the court. And then the probation officer did a report, and it was then brought to the magistrate, and then with the consent of the parents, it was decided now they have to do a more onerous diversion, because it's the children's fault that they, although there was no inquiry, there was no record of any inquiry as to the reasons for non-compliance, but the decision was then taken to get a more onerous diversion order, and this order was that the children should be referred to a child and youth care centre to attend a drug rehabilitation program, but there was no time limit on the stay in the child and youth care centre. And a senior magistrate picked up on this proceedings and then referred it for special review, and that's why it then landed before the Gauteng South High Court. And they then reviewed the case. There was a lot of postponements, but they immediately then released the children, and they also did an audit to see how many children were in that centre on basically the same circumstances. So that was the one part of the application, is just to get immediate relief for the children in their current situation, and then the court considered whether or not the continued arrest of children using or possessing cannabis should still be criminalized in light of the Prince decision of the High Court, which then indicated that adults, may now use and possess cannabis, and whether it's still justifiable to criminalize children, because with the Constitutional Court judgment, the criminalization of children for the use or possession of cannabis resulted in creating a status offence, and that is an offence where children can be charged for something that adults are allowed to do, and that was the questions that the court had to consider. So the court made it very clear in the decision that when the use or possession of cannabis by children is decriminalized, it is not legalizing it. So it's the same as with the adults. You cannot buy it and you may not sell it. So if you find a child and they have a few gram or something in their pocket, you should not be arresting and criminalizing that child. That is what criminalization means, and not legalization. So, and the court also made it clear, and all the submissions by the various ministers who were joined to this proceedings, everyone was very clear that we do, with this decision, it does not encourage or condone the use of or possession of cannabis by children. So by no means is it approved. It is just to say we should not be locking children up for this. But we don't encourage it. It's not healthy for them. They shouldn't be doing it, but we shouldn't lock them up if they do that. Selling of cannabis remains an offense. So if a child sells cannabis, he will still be arrested. He will still go through the criminal justice system. And that was also made very clear. So, and as I said, the question before the court is that should criminal type penalties still be imposed on children? So the other issue that came out in this case is the Section 8A of the South African Schools Act. So in terms of Section 8A of the Schools Act, it is very clear that the school can do searches just to look for dangerous weapons or to test for drugs or whatever, and following that should be disciplinary process in terms of the school internal school processes. The Act is the Schools Act is very clear. There cannot be a referral to the criminal justice system. So that is one of the issues that also raised the concern in this matter that I've explained to you, because following that search that the court did, that the school did, it resulted in the children being taken to court, which is not correct. And the court also found that the rights that were violated by children, if we criminalize them for cannabis, is their right to equality, because the adults are treated differently, their right to dignity, their right to freedom and security of person, the right to privacy, and the right of children to have their best interest considered as of paramount importance in all matters affecting them. And then, of course, a right to fair trial, because there were some procedural irregularities that happened. As I said, there was no inquiry as to why these 4 children did not comply with the diversion order. So basically what the court then did is it declared Section 4B of the Drug and Drug Trafficking Act inconsistent with the Constitution and invalid to the extent that it criminalizes the use and possession of cannabis by children. So that was the first part. And then the court also went further, because this now have to be referred to the Constitutional Court for confirmation. The court then further ordered that pending the law reform process, children may not be arrested or prosecuted or diverted for using or possessing cannabis. But that does not prevent us from taking other means, alternative means, less restrictive means and procedures to ensure that the child receives the appropriate assistance or intervention for cannabis use dependency. So it basically decriminalized it. It prevented children from being arrested for this going forward until the Constitutional Court has heard the matter and until the law reform process has been dealt with. So that provides that protection, but then we have to then rely on the less restrictive measures that we have available in our legislation to deal with these children. So the court further stated that children accused of a Schedule 1 offence may under no circumstances be ordered to undergo a diversion program which involve them to be detained at a child and youth care center. And I think that is a very positive a part of the judgment, because we don't want to detain children. It must be a measure of last resort. And the Schedule 1 offence, as you will remember, is your minor offences. So we should not be detaining children for committing minor offences. And as I stated earlier, the matter will now be referred to the Constitutional Court for confirmation. So if we quickly look at the various other options. So we have the Children's Act, which indicates anyone that have the acting in the best interest of the child can approach the Children's Court, and the Children's Court adjudicate matters involving the protection and well-being of children and to provide prevention and early intervention services. So your prevention and early intervention services will focus on psychological, rehabilitation and therapeutic programs, and the child in need of care and protection. The referral to a child or the description of a child in need of care and protection do include a child that is addicted to a dependence-producing substance and that is without proper support to any means that don't have support to obtain treatment for such dependency. And it also includes children that displays behavior which cannot be controlled by a parent or a caregiver, which we often find with children that are abusing substances. So those are the way that you can approach the court and get the necessary intervention for the court. And the orders that the court make when they find a child is in need of care and protection can include, in terms of the Children's Act, that the child be admitted as an inpatient or outpatient to an appropriate facility to address the child's need for treatment for addiction to the dependence-producing substance. So the child don't need to be charged with a criminal offence to get assistance in terms of the Children's Act. It also indicates that even if a child is not in need of care and protection, the court can still order the child to be admitted as an inpatient or outpatient to receive treatment for the dependence. And so the Children's Court do have a wide discretion to ensure that children receive the necessary interventions. The next act is the treatment of Prevention of and Treatment for Substance Abuse Act, which also then focuses on the objectives of the Act is to specifically provide for vulnerable persons to get access to rehabilitation centres, and it ensures that there are services available and accessible to all service users, including women, children, older persons, and persons with disabilities. So the purpose is to admit persons to treatment centres, and then to admit them to public treatment centres to undergo treatment and rehabilitation and to receive skills development. Then it also provides specifically for children who are abusing substances, who are affected by substance abuse, and then it has a voluntary treatment or service users that can go into treatment, and that is where you apply for admission as a voluntary service user through the court, and then the court will then make an order to that extent. And it also provides for involuntary service users for treatment, and that is in instances where a family, a parent or a guardian or an adult can approach the court with an affidavit through a social worker to a prosecutor to apply for the child to be sent as an involuntary service user, because the child doesn't want to go, but they need to be taken up into the centre for treatment. And then Section 35 provides for the committal of a person to a treatment centre after the court done an inquiry to find out whether you know, this is the appropriate action to take. The last instrument that I want to focus on is the National Instruction 3 of 2010 that was issued by the South African Police Service. So it provides direction to police officers how to render assistance and protection to children in relation to the Children's Act. So this is children in need of, those children that are in need of care and protection. So as I said earlier, children who are dependent on substances are regarded as children in need of care and protection. And this instruction is to ensure that the police don't just ignore them or, you know, don't attend to them, that they must take, they must provide them with intervention, so that we ensure that they don't fall through the cracks. And I think that is also very applicable, because there's always a gap for me in terms of children that are abusing alcohol, and I don't think there's enough attention to that, because with the other illegal drugs or whatever, the police will arrest them because it's a crime. But in terms of alcohol abuse, the fact that the child is drinking alcohol outside of a tavern is not a crime in itself. The police must now find out who sold the alcohol to the child, but they don't arrest the child for drinking alcohol outside of wherever, on the street or wherever they find them. So in terms of this instruction, the police officer must, within 24 hours, make a report into the occurrence book and note the particulars of the child, and also the particulars of the designated social worker, because the police must now ask the social worker to conduct an investigation as to the child's circumstances, whether the child is in need of care and protection. And then the police officer must also get confirmation from this social worker that they did receive the case and that they are investigating it. So these are the measures that we will have to strengthen to ensure that children don't fall through the cracks, and we need to emphasize and train the police so that we make sure that children, the ones that are now using and possessing cannabis, are properly referred to social workers so that they can be investigated and that they can get the support that they need. And that is it from me. Thank you.
Wow, thank you, Dr. Badenhorst. Thank you so much for an extremely informative presentation. We have had a flurry of questions coming through, and we do have a little bit of time. So if you wouldn't mind, I'm going to pose 1 or 2 questions. And then what we will do is we will request that we would possibly be able to set up a recording and answer the other questions that we have not been able to get to in today's session. But as we spoke about beforehand, this is a topic that is at the heart of all our practice in terms of how do we deal with children and the use of substances, and particularly with the use of cannabis at present. So I've highlighted 3 questions that I'd like to pose to you, if possible, for the last 15 minutes. The first question was asked by Minaz ISSUP, and it was, when will the Criminal Justice Amendment Act 28 of 2019 come into effect? The second question was posed by Cheryl Blackenberg, and she asks, what measures are used by the court to determine criminal responsibility? And the third question I'd like to ask now is also from Cheryl Blackenberg. What happens if the child committed a criminal act at the age of 13 and sentence is passed at the age of 20? Does the Criminal Justice Act apply?
right. So I will start with the first question. The Child Justice Amendment Act 28 of 2019 has already been assented to by the President. I think there was some media reports in June last year when it happened. But we are busy with the regulations. So in order for us to put this amendments into operation, we need to amend the regulations to fit the amendments that were made to the Act. And we are currently busy with that. It's in the final stages. It has to be approved by Parliament, but as I said, it's already been translated into another language. You know, if they publish the acts, it's usually in two languages. So it has already been translated. It's in the last stages of being submitted to the Minister for tabling in Parliament. I'm pushing to get it done as quickly as possible, because I was involved for a long time to get it done. So I'm also very excited for it to get into operation. So the measures that the court take into account when determining the criminal capacity of a child is basically they can get the criminal capacity evaluation by a professional, the suitably qualified persons that I was referring to earlier. That will assist the court, but also the evidence before the court. Sometimes you will find that the child will hide after they've committed a crime, or they will, you know, the way that they act before, during, and after the crime will give you an indication. You might find children that will break into a building and then someone will stay outside to keep a hideout or look out. You know, those are all indications that the child know that they are committing, you know, doing something that they are not supposed to be doing. I don't know if that's answered the question, but because the criminal capacity evaluations have now been made part of the Child Justice Act. As I said, with common law, we didn't have a proper framework. And when I was a prosecutor, you would call the parent to the stand to ask them, have you taught your child the difference between right and wrong? Do they know it's wrong to steal? And because of being, indigenous or unaware of what's going on, the parent will answer these questions thinking that they are assisting the child. In the meantime, the prosecutor is busy proving criminal capacity. So by bringing it into the Act, courts do get those professional criminal capacity evaluations, and then, you know, use that as part of the facts that they consider when considering the criminal capacity of the child. So with regard to a child that is 13, if I understand the question, they committed the crime when they were 13, but they are only apprehended when they are over 18. Is that correct?
So the question as it was posed reads, what happens if the child committed a criminal act at 13 and at 20 sentence is given? So what I'm assuming is that they committed the act and they went into the system or something like that. There was delay in sentencing and they're only sentenced once they are considered adult. Does then the CPA apply to that case?
Yes, there is a constitutional court judgment that emphasizes that the court should look at the age of the commissioning of the offence. So if the child is 18, it should play a role. If the person is 21, some of the sentencing options, for instance, won't be applicable anymore, because you can't take a 21-year-old to a child and youth care center, for instance. But that is something that the court must take into account. And even if we if we register these cases on our database, we have the compulsory field is the age at the time of the offence. That is important, because you might commit a crime today when you're 17, and tomorrow is your birthday, and then the next day you you commit a crime today, and tomorrow is your birthday. Now they catch you the day after your birthday. You're now an adult, but the Act takes you back to the child justice provisions, to protection. Yes.
Okay, very interesting. You know, really, Dr. Badenhorst, this is such an interesting topic. I think we could spread it over a whole series of webinars, and I think the amount of questions that we have had coming through are evidence that this is something that we as professionals in the field of substance use, we need to know these things, and we need to have people who are experts in the field sort of giving us the insight into what we know. I mean, it's very easy for us to read an act and sort of make an understanding from our own perspective, but is that really the perspective that we are we are understanding it correctly from? So this has really been a fascinating topic, and we really want to thank you so much for availing yourself of and availing your time to give us insight into your expertise. And we really do appreciate the fact that you've really laid out so many things for us to think about, and we are extremely excited to invite you back as ISSUP, in your capacity to give us more insight into this topic as we go along. So yes, thank you very much.
Thank you very much for the opportunity, and it's always a great privilege to share this information with as many people as possible, because it contributes to protecting the children, in conflict with the law, and children in general. Thank you so much. I really appreciate it.
It's a pleasure, and we will definitely be in touch with a further request for you to do a follow-up webinar with us. And definitely we will be in touch shortly to talk about answering the other questions that were posed that we don't have time for at present.
Thank you.
So thank you to everybody for attending. I can tell you today we had the record number in terms of attendees for our webinar with ISSUP and ITTC. We are very, very happy that you found it beneficial. Just the fact that you asked so many questions and there was such an engagement in the topic is fantastic. I can assure you, as ISSUP and ITTC, those who have posed questions that we have not been able to get to today, we will ensure that your questions are answered in a follow-up session where we will pose those questions to Dr. Badenhorst and record it and post it along with the recording of this webinar. So with that being said, I would like to thank you on behalf of ISSUP for attending our webinar today. Please remember that if you are not a member of the ISSUP South Africa chapter, please log on to www.issup.net and register as a member to ensure that you get the full benefits of being a member of our networking chapter, and that we can keep you up to date on upcoming webinars or events that we will be hosting over the next couple of years. Again, thank you very, very much, and we look forward to seeing you all again very soon. Thank you again, Dr. Badenhorst, and thank you ITTC and for everyone behind the scenes for assisting in making this a success. Thank you and have a great weekend.
Thank you.